I guess we should get started. I am the surprise substitute moderator here. I am not Ari Berman. I am Paul Smith. Ari has a deadline at The Nation magazine, and he couldn't get down here to Washington. He sends his apologies. I got substituted in here because I work on voting rights myself a little at Campaign Legal Center, where we do voting rights and campaign finance. I also have a fairly long list of voting rights and election law cases I argued in the Supreme Court. The list of which cases that I've won in the Supreme Court in that area is a lot shorter, but as you'll probably hear along the way. Our topic today is barriers to voting of various sorts that have been erected around the country. These obviously include voter ID laws and limitations on other limitations on voting, such as cutting out early voting, registration barriers, et cetera. Just a couple of minutes of introduction. There are a couple of key Supreme Court cases that have laid the foundation for these laws and are sort of lurking in the background in how they get litigated. One of them is the Crawford versus Marion County case, which yours truly lost in 2008. The case involving the Indiana voter ID law, which the Supreme Court upheld 6-3. And basically was willing to take at face value the legislature's determination in Indiana that there was a problem of voter fraud or potential voter fraud that a voter ID law would be useful to combat. The other case is Shelby County case, which in 2012 eliminated Section 5 of the Voting Rights Act, effectively nullified it. And what that has done is eliminate the requirement that had previously been imposed on a number of states, particularly in the South, that whenever they change their voting laws, their election laws, they had to go first to get pre-clearance either from the Justice Department or from the three-judge court here in the District of Columbia. So as a result of that, we've seen a lot more changes in voting laws seemingly designed to make it harder to vote that have been passed and enforced and are now having to be challenged directly in court, usually under Section 2 of the Voting Rights Act, which is the general provision in the Voting Rights Act that applies nationwide that says any form of barrier to voting that is based on race that results in a denial of voting rights based on race is a violation of the Voting Rights Act. So we have litigation to talk about that has actually been reasonably successful in terms of turning back some of these laws in places like Texas and North Carolina. On the other hand, what we have here in Washington is an administration that is seemingly committed to the idea that there's massive voting fraud out there, a new commission that has been appointed by President Trump to investigate his claim that 3 million people voted illegally against him and presumably try to come up with some support for it, maybe with recommendations for federal legislation or something else. We'll have to keep an eye on that as we go forward. I do think eventually what we're going to do, in addition to talking about these voting barriers, voter ID laws, and the like, is move into redistricting litigation, which is also a very hot area these days. And of course, the way districts are drawn can, even if it doesn't prevent people from voting, affect the impact of your vote, dilute your vote, either based on race or based on party. And so that's an additional part of the story in what might be viewed, at least from my point of view, as a kind of an effort to push back against full democracy and change the outcome of elections in one way or the other. We have a distinguished panel here to discuss these issues with you today, starting on that end of the table. I won't say far left, whatever.
I'm comfortable on the far left.
Is Anita Earls, who's Executive Director of the Southern Coalition for Justice, based in Durham, North Carolina. She's litigated a long series of incredibly important voting rights and redistricting cases, including a challenge to the new North Carolina congressional districts that she and I will be taking to trial in 2 weeks in Greensboro. She's one of the real leaders of the voting rights bar and a hero. Marcia Johnson Blanco is the co-director of the Voting Rights Project at the Lawyers Committee for Civil Rights Under Law, obviously an incredibly important organization in this area. In that capacity, she directs a wide variety of efforts to protect and expand the franchise, the right to vote, Not on the litigation side, but almost everything else that the Lawyers Committee does in this area, she does. Then we have Will Consovoy, a friend of mine from the Supreme Court Bar, who is a partner at his own little firm now of Consovoy McCarthy Park. Is that right?
Yes, that's right.
And his involvement with voting rights has included work on the Shelby County case that I just mentioned when he was at his old firm of Wiley Rhine, as well as arguing the Evanwell case, which is a case that was decided recently by the Supreme Court and dealt with the really interesting issue of when you're trying to equalize the population of all the districts, legislative districts or congressional districts, which people do you consider? Do you consider everybody who lives there, total population, including non-citizens and children, or do you only consider, as Will argued you should, eligible voters, citizens of voting age? A quite important issue which the court didn't definitively rule on. It certainly said it was okay to consider total population, left open perhaps the possibility that you might do it some other way, and we may want to talk about that as we get on. Will is a former law clerk for Justice Thomas, co-directs the George Mason Supreme Court Clinic, and I want to particularly thank Will for bringing a little, perhaps a little more ideological diversity to this panel than it might otherwise have had. So I appreciate that.
Happy to be here.
And finally, Fernita Tolson is a professor at the University of Southern California Gould School of Law. A major focus of her teaching and her scholarship is election law and voting rights. And so basically she's here because she's supposed to know about everything and clarify it all for us. But thank you, Fernita, for being here. I wonder if we might start with Anita and talk a little bit about, there's so many different things you could talk about with respect to North Carolina, but since this panel, at least as it's in the book, is geared toward the voting barrier side of things, could you tell us a little bit about the decision of the Fourth Circuit that was recently had cert denied on the North Carolina voting barriers or voting, we call them voting barriers, other people might call them different things, and what's going on, what's likely to happen next in North Carolina in the area of voter ID laws and that sort of thing? Is that a good place to start?
Right. So thank you so much for that kind introduction, and a huge thank you to ACS for inviting me, and I just am really excited to be here. We call it the monster vote suppression law, and what was significant about the Fourth Circuit's decision overturning the lower court in that case was the essentially applying an Arlington Heights standard and finding that the law was intentionally racially discriminatory, saying that you had to look at all elements of the law together. You couldn't first look at voter ID and then look at the decision to stop out-of-precinct provisional ballots, then look at the decision to end same-day registration, then look at the decision to cut back early voting, that you had to consider all of that together in the context of the North Carolina conditions around voting. So maybe New York State doesn't have same-day registration, but in a state like North Carolina where black registration had lagged behind white registration rates, and there had been finally just a recent history of more parity as a result of implementing things like same-day registration, that you had to take all of that into context when you were evaluating what was the intent of the legislature behind the law. And the Supreme Court ultimately not taking the case was really about voters. It was about voters in 2016 coming out and electing a Democratic governor and a Democratic attorney general, who then were willing to take the position, since they were defendants in the case, that they no longer wanted to pursue their petition for certiorari. So I credit the voters with that win as much as anything else. But not to be deterred, our legislature decided that what the Supreme Court really meant, or at least what the Chief Justice did in his short little explanation of the procedural history of the case and his unremarkable statement that denying cert was not a decision on the merits, they took that to mean, oh, the court wants us to pass another voting ID law, another vote suppression law, so that it can come back before them. So they are busy doing that, and we are, working to be ready to put in the legislative record what needs to be there. But frankly, litigation isn't the only answer in fighting these vote suppression measures. And I don't want to go on for too long, but I have some examples from other states as well of how, as lawyers on the ground with that litigation tool, we are also, it's really important that we are partnering with groups that care about civic engagement, and throughout the litigation of this case, the North Carolina NAACP was in the streets marching and really kind of raising awareness. And part of the big picture here was that the litigation helped them do that. It helped them turn a law that was intended to suppress votes into a law that was motivating people to get out and vote. So that sort of big picture is part of the response to these vote suppression measures.
There's several really interesting aspects about this case, Anita. One was that the decision you're talking about, looking at the whole package of things together and concluding from that, based on Arlington Heights, that there was racial intent, was a decision of the Court of Appeals reversing a finding to the contrary, a finding of fact to the contrary by the district judge after a full trial, which is quite unusual, and that certainly became part of what the cert petition argued when the state legislature kind of was leading the charge in terms of seeking cert. And then you ended up with this situation where there were two contending people saying, they spoke for North Carolina, the new Democratic governor and attorney general, but then the lawyers were hired by the legislature, and so the court would have had to resolve an issue really of state law, who was in fact the right representative of the state in order to grant cert. And that's, I guess, what Chief Justice Roberts said was the real reason, at least for his vote, to deny cert. But it does end up sort of leading to this question of whether we're going to go through this endless round of new laws every time we strike one down.
Which is kind of why Congress thought Section 5 of the Voting Rights Act was necessary.
Exactly. An important point to understand how the world has changed and why we're filing Section 2 cases all over the place. Now, Marcia, tell us about your work and what kinds of voting barrier problems you've been seeking to combat around the country at the Lawyers Committee.
Okay. So I oversee the Election Protection Program, and it's a coalition of hundreds of organizations and law firms that support voters. And it is unfortunate that we need an army of lawyers and advocates and grassroots community leaders to help to protect the vote. But that's what we organize around election protection. And in 2016, we saw the impact of the restrictive and suppressive laws that are being passed. In North Carolina, the court struck down the monster bill, but during the North Carolina primary, for example, it was in effect, and we saw voters being turned away because poll workers didn't understand the law, and there was a lot of confusion there. Texas is another state where there's a restrictive voter ID law. We got a very important decision there that the law was discriminatory, and there was an interim remedy before the November election. And I think what the state officials did there is indicative of what we're seeing, where we would get a win on the litigation or a remedy that would allow more voters, eligible voters, registered voters, to be able to vote, but then the elected officials would push back against that win. So in Texas, there was an interim remedy that said if you didn't have one of the restrictive IDs, you can produce a non-photo ID with your name and address on it, and then sign an affidavit that there was a reasonable impediment. And then the official said, and we will charge you with perjury and penalty if you we think you did that erroneously, and so that served as a chilling effect, and it's something that we continue to see. We also saw voters being purged from the rolls improperly. We saw that in Hancock County, Georgia, where the county sent the sheriff to voters doors for them to confirm that they were eligible to vote. We even saw that in New York City, where thousands of voters were erroneously purged from the rolls when they moved within the city. We also saw consolidation or reduction of polling places having a suppressive impact. Arizona famously reduced their precincts for the primary from over 200 to 60, and there were 5-hour or more long lines there, and we had to bring litigation to address that. And then, as Anita mentioned, it's really important that the community is involved in the voting issues and being aware of what's happening in their community. In Macon-Bibb, Georgia, for example, they were going to close a polling place, and in a majority African American community, and decided in their wisdom that they were going to move the polling place to the sheriff's office, and were non-responsive when the community objected. And we were able to find in the Georgia statute that the community could petition to have the polling place moved to a location that they wanted it moved to, and were able to do that. So again, litigation is not always necessary, but in order for it to for us not to have to get to litigation, we need community engagement and community involvement to make that happen. So I'll pause there.
No, that's fine. But one thing I would just pick up on, Marcia, is this issue of what happens after you win a case, whether there really is compliance with it. We saw that in North Carolina, too. Even after the big monster bill was struck down, the local election officials continued to do what they could to keep the suppressive effect in effect for the general election, right?
Yeah.
That's right, Anita.
That's right.
And the other thing we're starting to see a lot of is this reasonable impediment affidavit requirement. As a way to make the voter ID laws seem less onerous, you can say, well, all they have to do is swear that they have an impediment from getting the ID, and we'll let them vote. But people are, at least so far, it seems to be quite reluctant to sign under oath that they have a reasonable impediment, not generally legally trained people lacking voter IDs, and concerned that they're going to be prosecuted for perjury later on. So it tends to be a kind of a hollow escape hatch, I would say.
Yeah, and I would mention, in Texas, the legislature just recently passed a law to address the court's finding that the ID law was discriminatory by putting into law the interim remedy, but keeping the reasonable impediment penalty, which would be a felony and subject to jail time if you use it. So they claim they're trying to cure the discrimination that the court found through those means. And so, yeah, it's just intractable.
Yeah. Fernita, why don't you give us your perspective on where we are in this sort of post-Shelby County world of trying to enforce the right to vote, and where you see us going and what we can do going forward in this with an administration that's obviously not friendly to us on these issues as well.
Okay, well, it's like, where do you start, right? We are.
That's why I opened an open-ended question. I'll let you figure out what you want to talk about.
So, I think that for those of us who really care about voting rights and having expansive access to the right to vote, things are tough, and it's interesting to me because I say this at a time where if you think back to the last year, I know that those who are voting rights advocates have had some significant wins, right? So it's not as if, at least on the litigation front, things are as bad as they could be, but I definitely think that we have some obstacles that we will have to overcome. And part of it is, a lot of this litigation is necessary because of Shelby County. But also, one of the things I want to focus on in my comments is the nature of these wins, right? So I think that the voting rights advocates are doing amazing work. Like, they are literally heroes to me. I feel like they are out there fighting a good fight. And my role in this is to try to write things that they can use. But in the process of doing that, one of the things that I look at, for example, we've had some recent Supreme Court cases that are trying to flesh out the Shaw claim. Everybody remembers Shaw from law school, I hope. I hope you took election law in law school, right? And so the racial gerrymandering claims, and most recently the Cooper case out of North Carolina. And so it seems like you really do have a court that's willing to sort of police some of the things that have been going on. But one of my concerns in reading both the Cooper decision out of North Carolina and the Bethune-Hill decision out of Virginia is that I'm wondering what we are giving up in order to sort of achieve or at least preserve some ground in this fight. So, for example, in the Cooper case, which was really a wonderful opinion by Justice Kagan, one of the things that she focuses on is on the question of whether or not the legislature's decision to argue that they were trying to comply with they were trying to avoid Section 2 liability by the way that they drew the districts. She rejected that in part because of the absence of racial bloc voting. That seems fairly straightforward, but my concern is, how did we get to a place where we assume that compliance with the Voting Rights Act is enough to trigger strict scrutiny, right? That is something Justice Thomas has been advocating for years. That is one of the reasons why he signed on to the opinion, and that is the thing that keeps me up at night, right? So yes, we won, yay! But then I wonder about the concessions that we make in achieving this win. Another thing out of the Cooper opinion, and I don't mean to, Justice Kagan, she put her coalition together, right? She got the districts, struck down. But also this notion that partisanship, leaving the door open for the argument that partisanship could justify a racial gerrymandering. We need to close the door on that. So one of the things that Justice Kagan argues in her opinion is that, there's direct evidence that the legislature relied on racial criteria in drawing the district. And this is why she rejects the argument that partisanship predominated. But she leaves open the door for the argument that we could sustain a district if there's more circumstantial evidence of intent based on partisan grounds. So that is another thing that keeps me up at night. And honestly, my work, I focus a lot on Section 2 of the 14th Amendment, which is a provision most people don't even know about because it's never been enforced. So Section 2 of the 14th Amendment allows Congress to reduce a state's delegation in the House if the state abridges or denies the right to vote. The penalty has never been enforced, but that does not mean that Section 2 hasn't figured prominently in the Supreme Court's jurisprudence. Most recently in the Evanwell decision, where the court looked to Section 2 to support its argument that Section 1 did not require that state legislative districts be reapportioned based on registered voters, because that argument was rejected with respect to the apportionment scheme in Section 2 of the 14th Amendment as it applies to congressional districts. And so Section 2, and probably most infamously, is the Richardson versus Ramirez case, where the court looked to Section 2 in order to hold that felon disenfranchisement did not violate Section 1 of the 14th Amendment, because Section 2 exempts felon disenfranchisement from the penalty of reduced representation. And so Section 2 has played a role, even though its penalty has never been enforced. And so I ask the question when I read these opinions, well, why doesn't it play a role for good, right? Just in terms of, it talks about abridgment, right? Abridgment of the right to vote. It doesn't talk about abridgment on the grounds of race. It doesn't talk about abridgment on the grounds of partisanship. It just talks about abridgment. So why is it that the court is willing to leave room for a state to rely on partisanship as a grounds for imposing a onerous redistricting requirement when you have language in Section 2 that talks about abridgment broadly defined, right? Why do we leave that door open? And so I do think it's part of the, given the fact that we are at a time where voting rights really are under siege, yes, we do have to sort of deal with, we basically have to take wins wherever we can get them, right? I understand that a lot of the language in these opinions are an attempt to cobble together a majority, but I do wonder about down the road when we have to revisit these precedents, if this is language that can be used in order to circumscribe voting rights further. Now I'll stop there.
Good. Since Vernita's taken us in the direction of the recent racial gerrymandering cases, Will, let me just make sure we're all on the same. These were the cases, Alabama had one, and Virginia, and then North Carolina, cases in which the line drawers added additional African-American voters into the existing African-American districts and said they were doing it to comply with the Voting Rights Act, and the court has found in all those cases that they didn't really have any valid Voting Rights Act reason to up the African-American percentage in these districts, and so therefore found to be a racial gerrymander. What's your perspective on that line of cases?
Yeah, it's an interesting and obviously timely issue, and I'd like to talk about it, but also sort of in the terms of voter ID as well. Because,
I'll take you back to Shelby County and voter ID too.
I'll take it all on.
All right, go for it.
I will defend it all. Okay.
You have a lot of friends in the room.
I can tell. I can feel the love. So let me start with this basic premise. On the voter ID cases and in these Shaw cases, I think you will not find any disagreement from me or any of the conservative members of the Supreme Court with the following proposition. If there is evidence of intentional racial discrimination through Arlington Heights test or any other test, and it is proven, no one is interested in upholding those provisions. I think you see that in the votes that were cast, particularly in the Cooper case. It was Justice Thomas who cast the deciding fifth vote to strike down the North Carolina plan. It was Justice Thomas in the dissent in the Virginia case who would have gone farther than the majority in striking down the Virginia districts on the use of race. It is Justice Thomas who has been the consistent voice on this from the beginning.
Not the other conservatives so much, though, right?
Justice Alito on the one district, he agreed. And this is important. In the Alabama case, the dissenters in that case were dissenting on procedural grounds, on standing. In the North Carolina case, Justice Alito's dissent was confined to a narrow fight over factual issues on one district and an argument about whether an alternative map is required. Not necessarily a strong endorsement of what North Carolina was doing. So these voter ID cases are important cases, very important, in terms of the impact on the particular states. I don't think, though, because they've all been decided so far, with the exception of the Fifth Circuit, which I'll turn to next, on intentional discrimination grounds, they really involve novel issues of law. They are idiosyncratic to the states that are involved. Now, the Fifth Circuit held that the Texas voter ID violated the results prong of Section 2. And that, I think, is a very complicated issue involving questions about overlap between things that correlate with race and race itself, what it means to deny or abridge the right to vote. Now, the district court has recently found that there was intentional discrimination as well. And if it goes up the chain again on that issue, I think the same narrowness will apply. But if it goes to the Supreme Court on the results prong, I think you may see, I would suggest there may be a setback for those who are trying to advance the argument against voter ID laws. I think the intent arguments have seemed to find much more favor in the Supreme Court.
It's been interesting that most of the judges, including, for example, Judge Moss writing the North Carolina opinion for the Fourth Circuit, and certainly the district judge in the Texas case, have been really interested in going as far as they have to find intent. And it may well be that they share your instinct that using the results test of Section 2, kind of a disparate impact-ish
Right.
test, to throw out these kinds of laws is problematic in the view of maybe 5 justices.
Yes, I mean,
I get. Would it be your prediction, speaking to us from the right-wing side of the world here, that Section 2 itself, the results test itself, is at risk of being held unconstitutional? That there's a right case in the Supreme Court?
in the near term, no. I mean, what's interesting is, and quite odd, is the results test was, the modern results test was enacted in 1982, and yet the Supreme Court has never passed on its constitutionality. And both Justice O'Connor, when she was on the court, and Justice Kennedy have gone out of their way to note that in opinions. So it is not just the Justice Thomases of the world who have expressed doubt. But I don't think in the near term the parties have not argued that. I do think if redistricting cases in particular, but also in the voter ID cases, if the court believes that the states are being put in a catch-22 of if you use race too much, you're going to violate the Shaw line, and if you don't use race enough, you're going to violate Section 2, I think you may not see Section 2 overruled, but you may see it narrowed in a way that members of this panel will disagree with. And I think that is a concern that has been raised. I think you saw that in the oral argument, certainly in the Virginia case, where Justice Breyer certainly was looking to make sure the states aren't in those catch-22s. But just pulling back on the broader picture here, I think it's just important to remember when you look at the denial of cert in the North Carolina case, but also really the redistricting cases, I think these cases are a vindication of Justice Thomas. The dissenters in Shaw, the dissenters were Justice Ginsburg, Justice Stevens, and Justice Souter. It was the Lawyers Committee and the ACLU who opposed in amicus briefs in those cases the creation of the Shaw claim.
Back in the 90s, yeah.
Yes, right. They opposed it. They thought it was wrong. They thought it was ideologically unsound. They thought it was bad law. They are now relying on those cases. Now, they're... Yeah, so...
The question from the audience is, could we hear what the Shaw case,
Yeah,
the
so-
Shaw line of cases is really about?
Essentially
which is
what it says-
Not the easiest question to answer,
Yes.
but you can try.
Yes, I would say, and I'm sure people will disagree, there's much more nuance than this. If race predominates in the drawing of districts such that it looks like you're trying to create segregated districts, strict scrutiny will apply, and you must have a compelling government interest which might or might not be compliant with the Voting Rights Act, and it must be narrowly tailored to meet that compelling interest, what we would think of as ordinary strict scrutiny. That's essentially, I think, what Shaw holds. I think Miller v. Johnson, which is a case that expands upon Shaw, is even clearer about that.
Right.
And that is the ground. That was opposed by Justice Stevens and Justice Ginsburg in dissent in
So
this case.
just to let me elaborate a little bit. Back in the 90s, there was it was clear that states had an obligation to try to create majority-minority districts under the Voting Rights Act. And they were doing that, but they also were doing it in a way that they had these incredibly ugly districts that were being drawn, like the one in Shaw was the one that went down the highway from Durham all the way to Charlotte, picking up black neighborhoods. They had these incredibly awful ink blots in Texas that led to the Bush versus Vera case. And what the court said is there's a difference between just deciding to create a black or Latino district and doing it this way, where race becomes predominant in some way. And so there's kind of this is where the catch-22 comes in, where the jurisdiction feels like it has to create the minority district, but if they go too far in considering race, somehow they're going to be attacked as having allowed race to predominate, and there is this sort of sweet spot they're supposed to find in between. And now as we've come into this decade, where the Republicans in the South have been packing blacks into the districts and saying they had to do it because of the Voting Rights Act, pretextually, it is the Democrats who have been using the Shaw line of cases to try to unpack those districts, saying that race predominated because you set for yourself an artificial goal of keeping the racial percentage at 55%, or in Alabama it was like higher. And you don't need to do that for any legitimate justification, and so therefore race predominated in the drawing of those districts, and the districts have been held unconstitutional consistently by the Supreme Court at the behest of the Democrats, which, as Will points out, is kind of a switch of who's suing who using the Shaw line of cases. I hope that helps a little. It's not the easiest area of doctrine.
Right.
Can I make one point?
Sure.
And actually, in response to something that you mentioned about whether or not we might see the invalidation of Section 2. And really, that's
I was going to go there next, Vernita, so go ahead.
Oh, great. Okay. So really, that's one of my concerns in reading recent opinions. It seems like it's less so in the Bethune-Hill case because, of course, Section 5 is really not an issue anymore, so you won't see that in the 2020 round of redistricting. But I'm wondering how we can reconcile a jurisprudence that points to a state's attempt to avoid Section 2 liability as evidence of racially discriminatory intent, essentially. And argue that doesn't bring Section 2 on a collision course with the Equal Protection Clause. And that's what I'm trying to figure out, and that's my concern about where this precedent, even though it sort of vindicates minority rights today, where that will leave us when we embark on the 2020 round of redistricting.
Well, there clearly is an element in the conservatives of the conservatives on the court who think that any kind of discrimination claim that's not based on intent should be invalidated. And then we saw that in a housing case out of Texas a couple of years ago involving the so-called disparate impact test, which was almost held invalid as unconstitutional by requiring you to consider race in your policymaking. But Justice Kennedy was unwilling to go that far. He, in fact, wrote the majority opinion in that case, allowing the disparate impact test to continue to apply. And so as long as Justice Kennedy's on the court, it would certainly be my view that Section 2's results test will probably be okay. But I think it's very much at risk in a post-Kennedy world. That is the project that the Chief Justice and others have embarked on a long time, which is, as you said, they're okay with intent-based discrimination claims, but nothing else.
Right, and of course the housing case was a statutory case, so it's a little bit different.
Yeah.
I think the case that really, is most pertinent here is the Ricci decision, the firefighter case, where the question was, can New Haven, Connecticut essentially engage in disparate treatment against non-minority firefighters in order to ensure that they don't get disparate impact liability on the promotion exam? And the court struggled with the issue. It was a 5-4 decision written by Justice Kennedy, and what the court did was incorporate the strong basis and evidence test that actually comes out of these voting rights cases into Title VII. And so I don't think in the near term Section 2 is in serious jeopardy of being invalidated. I think really aggressive uses of it make that slightly more likely. I do think, though, that there is a real chance, and obviously, well, not obviously, but I would say I agree with this, that it should be carefully utilized and not so aggressively. And let me give you an example. because I think the voter ID cases are not necessarily cases that would draw it into jeopardy. I think early voting cases are the weakest version of using Section 2 that would draw the most criticism from the court. I think it's very hard for the Supreme Court to accept the idea that New York can have no early voting, but Florida could lose under a Section 2 results test for reducing early voting from 14 to 7 days. The idea that having only 7 days of early voting. Now, if there's intent to discriminate, again, let's bracket that off. That's a different issue, totally separate, but purely on impact. If the idea that where there's no requirement to have any early voting, but you go from 14 to 7, denies or abridges the right to vote for anyone, is a proposition that will receive a lot of skepticism from the Supreme Court, and I would not think that would be the vehicle you would want to test how broad Section 2 could be litigated. That's just my view. Maybe others
I think
disagree.
you have to have a baseline, though, right? And I don't think it's odd to think that the pre-existing electoral scheme is a fair baseline to judge whether or not something is an abridgment.
Well, that would certainly be the rule under Section 5. Section 2 doesn't have that baseline.
Anita, you want to weigh in on this as a person who had to attack the elimination of some of the early voting requirements?
Well, I do, but I cannot hold my tongue completely on the Shaw question. So I'm an attorney who represented black voters in the Shaw litigation, arguing that the congressional districts 1 and 12 in North Carolina in the 1990s were not racial gerrymanders, and that the whole theory that was being advanced was not legitimate. And I am an attorney who represented black voters in 2011, arguing that the legislative districts and congressional districts drawn in that same state were racial gerrymanders. And so how did that happen? Conditions changed. In 1990, you needed a majority black district to elect a black congressperson from North Carolina. We had not had anyone since George White and post-Reconstruction. Over 100 years of no African American to Congress from North Carolina, a state that had more than 22% black residents, voters. So, but by the time we got to 2011, we were electing members of Congress from districts that were 42, 43% black. Same thing with our legislative districts. In other words, the Voting Rights Act remedy was working. Racially polarized voting exists, but it wasn't having the effect, that third prong of Jingles, it wasn't having the effect of keeping black voters from electing their candidates of choice. And the packing of black voters in more majority black districts than we'd ever had in the state legislature was actually ultimately weakening their influence and was a form of vote dilution. So that's, from my perspective, representing the interests of black voters, what was going on there. In terms of the vote suppression measures and whether Section 2 is a good tool to combat them, I would just like to switch to give you some examples of other tools. So I acknowledge there's some challenges in fitting these vote suppression measures into a Section 2 framework. That Section 2 has been used much more frequently for vote dilution in the redistricting context than it has been in the challenging other aspects of election administration. So what are some of our other tools? Sometimes the NVRA is what we need to use, but I also think there are some state law possibilities. And let me.
What's the NVRA?
The National Voter Registration Act. That addresses mechanisms that the state has to have in place to facilitate voter registration, and when and how states can purge voters from voter rolls. So when the vote suppression is taking the form of purging people right before an election, or when the Department of Motor Vehicles is not getting those voter registrations, or other state agencies aren't getting those voter registrations to the boards of elections, that's another way in which the NVRA can be a tool. But turning to state courts, because in some states they might be more promising now. And turning to this issue of voter fraud, in 2016, in our gubernatorial election in North Carolina, we had a very close election. There was a possibility that the Republican candidate would have lost by less than 10,000 votes, which then would have triggered a recount. So immediately after the election, his campaign filed challenges to voters in numerous counties throughout the state, saying that these voters were not eligible, essentially that they committed voter fraud, that they had voted when they shouldn't. And we had to we had to scramble to get a bunch of lawyers on the ground to go to those hearings. But what we determined ultimately when the dust settled was that most of these challenges were without base. There was no factual basis for them. They were matching people, a senior to a junior, people with different middle names, people of different ages, and saying that someone had voted twice, or they had voted out of state, or that they had a felony conviction, and it wasn't the same person. Almost none of these challenges stood, and there were hundreds of them. So we have now filed a lawsuit in state court against one of the challengers in Guilford County who challenged 3 voters. One gentleman who was challenged on the grounds that he had a felony conviction talked about how damaging that was to him. He did have a conviction 20 years ago, but he was eligible. He was fully eligible to vote. He was afraid. You know, he gets a letter from the Board of Elections saying, come to this hearing. You know, you've voted, you're not eligible to vote, and you've voted illegally, and it's a felony. So we filed a defamation action, which on Wednesday the court did not dismiss. So we're moving forward with discovery. And we think this is a way to reclaim the narrative, and that making these false allegations of voter fraud and accusing individual voters of voting when you don't have any factual basis for it, that in fact is defamation, and the people who do it should be held accountable.
And Paul, if I can add, you know, this question about why are we using Section 2 of the Voting Rights Act, I think we have to look back at the Shelby County case and the nullification of Section 5.
Right.
And particularly when you look at the facts on the ground, if you look at the Texas voter ID law, under Section 5, that law was found to discriminate against minority voters, and the day of the Shelby County decision, Texas chose to implement the law. Despite that ruling, in North Carolina, the Monster Bill was passed immediately after the Shelby County decision and the nullification of Section 5. So with that tool being removed, Section 2 remains
Right.
a tool that
It's
we
what we have,
as
right?
it may be.
Yeah. One of the things, Marcia, that people say about the nullification of Section 5 is that we have lost a mechanism for just finding out what's going on the ground. It used to be that every state, little county, little town that made any kind of change in voting in the covered states had to come to the Justice Department and tell them what they were doing and make a whole presentation about why and justify it. But nowadays, it's very difficult, isn't it, just to know what's happening, particularly at levels below statewide levels. What are you doing at the Lawyers Committee? Are you experiencing that? What are you doing about that?
Yes, we're definitely experiencing that, because unless the community is engaged and attending election official meetings and
Right.
finding out what's happening on the ground, it's hard to know what's happening in local jurisdictions. And I mentioned the Macon-Bibb example earlier. Because we've been working with members of the community who are engaged and being aware, they knew that this awful polling place change was about to happen, and we can do something about it before it rose to litigation. So that is a tremendous need that currently exists, and an ongoing concern of ours about what's happening in those local jurisdictions.
Sure.
Thought I'd jump in on Shelby County
Oh,
at
yes.
this point. So,
Defend your work.
so let me make a few points about Shelby, which seems to be the villain in a lot of these stories. The court held in Shelby County that the coverage formula was irrational. Now, there really wasn't much disagreement that by its terms, the coverage formula was irrational. And I think the post-Shelby litigation has shown it that way. Wisconsin is not a covered state. Alaska was a covered state. Counties in New Hampshire and Michigan were covered. It made no sense. So if you think that Congress is allowed to pass irrational laws, then you have a problem with Shelby. That's all the court held. Now, Congress has not gone back and fixed it, and I think there are obviously political impediments to doing that.
You would have to say so, yes.
Yes, enormous ones. But right. But tell me if the senators and congressmen from Illinois or Wisconsin or California or New York, if you looked at where issues of voting rights might be arising, would be willing to have their states covered. If the argument is, well, we just want the southern states covered because we want the southern states covered, no, you're not going to be able to build a coalition in Congress. Now, what we said to the Supreme Court about will the sky fall, we said there are numerous groups out there that are well-funded that will bring Section 2 cases. Courts have the authority to grant preliminary injunctions. They have the authority to strike down discriminatory laws. They can do so quickly if they have to. I think has been proven true. Now, if you just don't want to see these groups have to expend those resources, I just think we're not going to agree. If you don't think that requiring every jurisdiction of every covered state to submit every voting change to the Department of Justice is an enormous burden and an incredible departure from the normal way federalism works in this country, we're just not going to disagree. But I do think that, listen, I litigate racial preferences cases against Harvard right now, claiming they discriminate against Asian Americans. I would love it if no Ivy League school could impose a racial preference without getting the permission of the Department of Education first. I would love it if every school in the country had to submit a race-neutral alternatives report to the Department of Education and disclose all of their admissions data to the Department of Education on a public website so I could look for the schools that I think are engaging in discrimination that violates the law. That would be quite useful. That would be quite helpful. But I suspect many of the people in this room would say that's not how it works. Plaintiffs have to sue, plaintiffs have to bring cases, and you get attorney's fees in these cases if you win. There's every incentive to bring the case. So,
But what do you do about the whack-a-mole problem, which is basically you spend 3 years litigating a case, you get a victory, and then 3 weeks later they pass another law with a slight variation, and you have to start all over again.
I don't think you have to start all over again. One, courts retain jurisdiction over their injunctions, and if the court believes it's being evaded by behavior, that court in that case can hail the parties in, impose sanctions, and make it stop. And if that's not sufficient, if it's the subtle change of the law, bail-in still remains. Now, I would note that the same Fourth Circuit that struck down North Carolina's voter ID law said that bail-in would not be an appropriate remedy.
Let's pause here and make sure everybody understands what bail-in is, okay? There is an interesting provision in the Voting Rights Act that says, this is Section 3, we've talked about 2 and 5, now we're to 3. It says that if you're a jurisdiction that is found to have intentionally engaged in discrimination based on race in voting, the court in its discretion can decide to put you back into a preclearance requirement where you have to have for some period of time your changes in voting laws all pre-cleared in advance. And in the wake of Shelby County, in the wake of the demise of Section 5, and with the start of these various places starting to have findings of intentional discrimination in redistricting and in voter ID laws and stuff, the question of whether a court is actually going to do that to a jurisdiction, make them be in preclearance, is becoming very salient. It's being litigated right now in these cases. So now,
Yeah,
back
so-
up.
Well, you may also want to talk about bailout, even though, and let me explain why. Because in no other context do we require a statute to perfectly further its end goal, right? And that's kind of what I'm taking as your definition of a rationality, right, with respect to the coverage formula. We had bail-in for jurisdictions that were not originally covered. They could be bailed in. But we also had bailout for jurisdictions that were covered that had clean records with respect to discrimination in voting. And so, to me, you know, I question this notion of a rationality when we had a congressional record that was 15,000 pages long, 90 witnesses. Like, Congress did build a record. So, yes, they did rely on some data that was dated. We cannot argue with that, right? But at the end of the day, post-Shelby, it's borne out. All of our concerns about not having Section 5 is borne out, right? Wisconsin isn't covered. Ohio isn't covered. Texas is covered, right? North Carolina, covered. Parts of Arizona, covered. And these are jurisdictions, even Alabama, covered. These are jurisdictions that they don't know how to act right? We really need Section 5. And so, you know, I can't endorse a definition of a rationality that ignores the Voting Rights Act in its entirety, because there are other provisions of the Voting Rights Act that are also relevant to fit.
Right. So just so everyone understands what we're talking about, when I say rationality, the test for whether you were covered under Section 5, the test, not the evidence in the record, the actual test, was did you discriminate in voting in 1965? So in 2017, the measure of whether you should have preclearance for the next 25 years was based on what your state did in 1965. The Supreme Court said that is irrational. I find it hard to disagree, how anyone could disagree with that. Now, you might say
Did
it is
Texas
rational.
try to bail out? I'm sorry. I'll be quiet.
Yeah. No. So listen, normally you have to be bailout is like parole or probation. Normally you have to be found guilty first, okay? And if you're going to convict someone in 2017 based on something that happened in 1965, I think you have a hard time calling them guilty.
We could keep
But,
relitigating Shelby County, for instance. It's 5 years old at
I
this
think
point.
we are.
But let me ask,
Can I
Anita-
just add
go ahead.
just one point, and then we can leave Shelby County? So,
It's obviously a painful case.
but, you know, you can't just look at the formula in 65 and say that's it. Those jurisdictions continue to discriminate against voters, and that's what
Just what
Congress
Congress found, yes. Yeah. That's the answer. I mean, to the extent there's an answer. This is the way the.
Right, but that's not what Congress found, because Alaska was covered. Parts of New Hampshire remained covered. Towns in Michigan remained covered. Wisconsin remained uncovered. It was about 50-50 at
If
best.
anything,
Yeah.
the problem was the failure to bail in Ohio. That was the problem.
Right, so Anita, let me ask you this question. Returning to this bail-in concept that's now relevant in the post-Shelby County world, where an intentional discriminator could be put back into a preclearance mechanism, why do you think the Fourth Circuit in the monster voting bill, when they found intent, they thought it was so clear that they actually reversed the district court and said that the intent is so obvious, we're going to find your finding clearly erroneous. Why do you think that in that very opinion, without anybody even talking about it, they went ahead and said we're not going to bail North Carolina in under the preclearance, even though they could have?
Right. So I think partly it was a function of the fact that this was a huge bill, a lot of factual details. The record was enormous. The claims were multiple. There was just so much for the court to grapple with, and being pushed to do so in a short time period. And just to give you a perspective on whether the ability to get an injunction somehow remedies the failure to have a Section 5 preclearance requirement, you know, we estimate that during the time when we had elections, before we could get an injunction, and when the injunction we did get was only partial, roughly 30,000 voters who tried to vote in elections were not able to vote or didn't have their votes count. And that is a harm. And that's something that Section 5 would have prevented. I won't relitigate Section 5. So bail-in. So they couldn't do it because the record was so voluminous and they just couldn't focus on what bail-in would require. But I also think it's difficult for courts because there's not a lot of precedent. There's not a case law. It hasn't happened very often. And then the statute says that the court, you know, it's unclear whether the court has to say that you submit something to the court. Do you bail in every change that the jurisdiction makes? How do you decide which changes should be reviewed and which shouldn't? If it was a redistricting case, it might be a little easier because you could just say any redistrictings have to be pre-cleared. But in the vote suppression case, would they say any law affecting elections should be submitted to them? And does that court want to act as a reviewing body to determine whether or not a pre-clearance standard has been met? And the statute then also allows the jurisdiction, even if the court says, bring us your changes and let us make sure they're not discriminatory purpose or effect, the jurisdiction still has the option to go to the Department of Justice instead. So it's a pretty clunky process with not a lot of standards, and that I think it partly explains why the court just didn't grapple with it.
Right. Let me ask you, while you're speaking, Nita, to talk a little bit about what happened with the congressional districts in North Carolina in 2016. We were talking before about how the court held that the two congressional districts were racial gerrymanders, the two African-American majority districts that had been drawn in 2011 by the legislature, because they were overpacked with African-Americans for no legitimate Voting Rights Act reason. And so the map was held unconstitutional. The Supreme Court just recently affirmed that. But even while that case was pending in the Supreme Court, the North Carolina legislature had to produce new districts to use in 2016. And how did they go about it, and what's happening in 2 weeks in Greensboro?
Right. So the legislature did seek a stay pending appeal, which was denied, so there was a requirement that they redraw. And they took the position that the court opinion meant that they could not consider racial data, but that they could consider partisan data. In the committees and on the floor, the legislature, Representative David Lewis and Senator Rucho, who were the two legislative leaders, explicitly said this is a partisan gerrymander, and partisan gerrymanders are constitutional. They said we're going to draw this map using partisan data to make sure that we get a delegation that's 10 Republicans and 3 Democrats, even though the state is 50-50 roughly in its voting patterns. They said the only reason it's 10-3 is because we couldn't draw an 11-2. just over and again saying, we're going to make sure that we get the same partisan outcome. And it's kind of interesting to me that the dissent in the Cooper case was on this question of whether District 12 was race or politics, said that the plaintiffs had to come forward with a map that shows you can have the same partisan result without using race. And actually, that's exactly what the General Assembly did. They passed a new map with the same partisan outcome without using race. And so, in light of that strong record of intent in the legislature, and the fact that the elections under that plan yielded a 10-3 delegation, the two different groups filed partisan gerrymandering claims, one following the Wisconsin Whitford theory of partisan gerrymander, the other following more the Shapiro, Maryland partisan gerrymandering case theory, and those two cases have been combined.
All right, so you referred, just in passing there, to the Whitford theory. Let me just note, the Supreme Court has never actually held a map unconstitutional on the grounds that it was a partisan gerrymander, which is that basically the lines were drawn intentionally to help one party get more than their share and the other party get less than their share. They've considered it a couple of different times, and each time have sort of batted down the claims. And so that's why Mr. Lewis and Mr. Rucho in North Carolina thought they could be as blatant about the gerrymander as they were. There is, however, a case that's presumably going to be heard in the Supreme Court in the fall, the Whitford case. In Wisconsin, a 3-judge court last year had a trial on the assembly districts, state assembly districts, and actually by a vote of 2-1 held it unconstitutional on the grounds of a pure partisan gerrymander, and established a test that says if you intend to draw a biased map and the effects of the map are very clear, both in terms of the extreme degree of bias in the map and how durable that bias is likely to be, that it's likely to last through the decade, and there's no justification in terms of the particular characteristics or geography of the state, it can be unconstitutional. And that's a direct appeal to the Supreme Court, which the state of Wisconsin has taken, and it was conferenced yesterday. We will find out. I, among others, at the Campaign Legal Center, are representing the plaintiffs, so we're hoping that, we're sort of assuming that they're going to take the case, but we're hoping it'll be an affirmance about a year from now. What
was the alternative theory for Maryland?
Well, the common cause theory is a somewhat different one. Our theory, building on what we've seen the courts say in the past, is that a certain amount of partisanship in line drawing by legislatures is expected and not too problematic, but if you can show that this is way to the extreme end of the spectrum, one of the most gerrymandered maps, and we have measures that social scientists have come up with to allow those to be ranked. If you can show that, then it should be and is unconstitutional. The common cause theory is somewhat more aggressive, building on the First Amendment, and says basically if the legislature has intentionally put a voter into a district where that voter has no chance of having their preferred candidate win, that act in itself is a violation of First Amendment rights. It's basically a more aggressive argument that partisanship almost ought to be taken out of the game of drawing these districts all together based on the First Amendment. Is that a fair characterization? You know,
Yeah, I think that's...
And so, actually, both of those theories are sort of involved in the North Carolina trial we're going to be having in a couple of weeks, which makes it an interesting trial. And it's also being tried not knowing what the Supreme Court's going to say in June, so it's kind of it makes it complicated in that way as well, because we're all just making predictions about how the court may rule, even assuming the court rules in favor of the plaintiffs, which is by no means certain. It'll presumably be a 5-4 decision, in all likelihood, I would think. What do you think about our chances, Will?
On partisan, it's obviously a difficult issue. The court has struggled. Even within the court, Justice Kennedy himself has struggled with both sides of it. We were talking before the panel today. Justice Kennedy, in an earlier opinion, Reith was what, mid-90s?
2004.
Thought the court could not find a judicially manageable standard. Obviously, time and experience may show him that the court can, but he also joined Justice Alito's dissenting opinion in the Cooper case, which was not directly about partisan gerrymandering, but his defense of District 12 was, and Justice Kennedy joined some statements that were quite strong in defense of the legitimacy of partisan gerrymandering, notwithstanding the court's distaste for it. Now, whether Justice Kennedy joining that opinion is a signal that he simply agreed with the bottom line of Justice Alito's dissent or subscribed to all of the particular points he made in it Paul will probably find out at the podium. But I think there's a push and pull with the court on, you see in all of these redistricting cases, and it certainly showed up in Evenwell also, which is the court does care about discrimination at the redistricting level, all of them, but the court is hesitant to put themselves more in charge of drawing districts. Now, I think the litigants will tell the court, don't worry, it won't be so bad, we can do this, but the court's experience has been that it is really bad. And if you want to look at an example, and I'm not sure who's to blame for it, we could probably have a panel on that alone, but the Texas redistricting litigation, which started, I don't know, when I was in law school.
For that.
We started, but we're now.
Congressman DeLay is responsible
We're
for that.
they're about to have a trial in Texas over 2013 maps.
No.
Based on
More recent stuff.
Sorry, 15 maps based on discriminatory 2013 maps that were never used to determine districts that will probably never have a decision before 2020.
There is a lot of litigation in this area, that is fair to say. Let me ask you this question, Fernita. Do you have concerns that if partisan gerrymandering becomes an actionable claim, that will in some way be in tension with efforts to maintain full and equal representation for minorities? Is there a way in which the two doctrines interact that concerns you or not? Feel free to say no. I'm okay with that answer.
No, not really. I think that, so if you think back to Veith and also I can't remember the name of the case. It was out of Georgia. It was Cox versus
Larios.
Yeah.
Yes.
So Justice Scalia made a point in the Cox case, and it was like a denial of taking the case, but he wrote like a short opinion where he pointed to Veith as a decision where the court was really 8-1 on the question of whether or not partisan gerrymandering could violate the Constitution, right? The issue really was manageable standards, and it's sort of, and I would actually agree with that, right? So this idea that too much partisanship could be a problem, right? And so really the issue is manageable standards, and I think that that's right. But my issue is, It's more so with the notion that we can disentangle race and party, right? And so
if they both become constitutionally problematic, that's the sorting out is less of a problem.
Exactly,
then. Yeah,
right?
yeah.
And so that's why I think that sort of recognizing this claim and allowing courts to address this claim is okay, because then it eliminates that. But again, let me reiterate my earlier position. It shouldn't really be a problem now. Like, we don't need an actionable partisan gerrymandering claim to not allow states to rely on partisanship as a defense to a racial gerrymandering claim. But I don't think that there's necessarily a problem with recognizing the claim.
Let me change the subject, Marcia. And one of the things I know you've done a lot of work on involves felon disenfranchisement and purges as well, right? Voter purges, often justified in the name of getting felons off the voter rolls. Most famously, perhaps in Florida in the year 2000, when tens of thousands of people were thrown off the voter rolls who weren't in fact felons at all. Can you talk about what's going on in that area and whether that problem is something that you see solutions to? Because it continues to be a festering problem, it seems to me.
It does continue to be a festering problem. We haven't been able to tackle it in the courts. You know, there have been cases that have been brought, constitutional cases under the Voting Rights Act. Actually, your group is attacking it again in Alabama, and we'll see how that moves forward. But one of the issues with felon disfranchisement is that there's a lot of confusion because every state has different rules. And so you have your Maine and Vermont where you can vote even if you have a felony conviction in jail. And then you have your Floridas where you have a waiting period after you've served your term in order to be able to appeal to the governor to be restored. And so rather than focused on litigation, we are looking at avenues where through education, through having elected officials like Governor McAuliffe in Virginia, who is very aggressively restoring those with felony convictions, to the rules, there's an effort now in Florida to have a ballot petition to address the permanent felony convictions, the disfranchisements in Florida. So there are lots of different avenues that we're taking outside of litigation to address the issue of felony disfranchisement, because frankly, I think it's 1 in 13 African Americans who cannot vote because of having a felony conviction. So it's a very significant and important issue that needs to be addressed, and I wish you all the best in Alabama.
Well, it was
and
interesting. We were
look
down in
forward.
Alabama looking at other kinds of litigation and dealing with the African-American community down there. They said, if you really want to help us, do something about the fact that a huge percentage of our population simply can't vote because of felony disenfranchisement under standards of a so-called moral turpitude standard, which is applied disparately from county to county. So it was a kind of a big mess down there, and we'll see where that ends up. But it is a coming issue, I think, that people will continue to try to push back on.
Paul, can I make a quick point?
Sure.
So in Florida, and I know Marcia mentioned Florida. So the current system, it just came to mind because I recently went to a clemency hearing where people can petition the governor and 3 members of his cabinet to get their voting rights restored. And it's literally like being in a third world country. You know, he says things like, so, you know, do you drink? Yeah, maybe you should just, file a petition for us to reconsider it later, because I really don't think you should be drinking. Now, mind you, drinking is not illegal, right? But, it really is sort of, the governor and his cabinet taking a position that someone does not deserve to have their rights back because of his belief they're not comporting with some standard of behavior, right? And so really the constitutional amendment would go a long way towards cutting them out of the process and restoring these rights in a way that I think is important.
And this is an effort to put this on the ballot for a citizen.
Right.
Well, that's an interesting thing.
And a second thing is also in Florida, we have a state constitutional amendment, and I guess I shouldn't say we anymore since I'm going to California, but Florida. We have a state constitutional amendment which prohibits the state legislature from taking partisanship into account in drawing district lines, and the sky did not fall. And so I think that's just evidence that it doesn't have to be that way. So you can sort of look at Florida. Now, of course, they take partisanship into account, right? But I do think that it makes it less extreme. But Florida might not also be a good barometer because the state legislature is I think the House is 2/3 Republican. You know what I mean? So it's really, really hard to know. But my sense is that it has added some transparency to the process in a way that I think is important.
So, Marcia, you say whatever you want, but also I appreciate if you tell the story just quickly about what Governor McAuliffe's in Virginia's experience was, where he kind of did a mass clemency and then had to start over.
Okay, I'll start there, and then I do want to have a point on the race and partisan gerrymandering as well.
And we'll be getting to questions in just a couple minutes, folks, so hold your questions.
So in Virginia, also a state where if you have a felony conviction, you need to have the governor, petition the governor to have your rights restored. And Governor McAuliffe decided to do a blanket restoration of rights to those with felony convictions in the state. And this was challenged, and the claim in the challenge was that he had to do an individual assessment before he can restore rights.
This was a couple of 100,000 people, right?
A couple 100,000 before he could restore their rights. And so Governor McAuliffe has been very aggressively
Right. The Virginia Supreme Court actually threw out his original order, right?
throughout the order, and so he had to go back and
Get the auto pen.
get the
going.
auto pen going, and has just been actively and aggressively restoring rights, one at a time, rather than being able to do a blanket restoration of rights. And so, it speaks to the role elected officials can play in the restoration of rights, and we'll see how many he gets done before November or when the new governor comes in next year. On the partisan and racial gerrymandering, I just wanted to mention the litigation that we just filed in Georgia which sits at the intersection of racial and partisan gerrymandering, where there was a mid-district redistricting done in the state.
Mid-decade, you mean? Yeah.
Mid-decade redistricting in 2015, where in 2 districts, the Republican candidates won by very narrow margins, defeated their black Democratic opponents by very narrow margins. And so what the legislature did was to redistrict mid-decade to remove some of the black voters from the districts to allow the Republicans to have a better margin of victory moving forward. And so we've challenged that redistricting on both partisan and racial gerrymandering grounds.
Okay. Does anybody else up here want to have anything you feel like you should have had an opportunity to say? No? Okay. I think then maybe we can open it up to questions from the audience. We have about 18 more minutes. Make sure, though, that if you have a question, you come to the microphone so it can be recorded and we can all hear you. So, sir.
So, unlike most everyone here, I'm not a lawyer. I'm a programmer, and I deal with data. And I'm wondering how you all characterize the harm on both sides of people voting who shouldn't vote and people being disenfranchised, and how you present that to the courts. Of course, my emphasis would be, what data do you use and where do you get it? And how can we help you get more of appropriate data, whether it supports your case or not? So that's my question.
Anyone want to address that?
Well, I can say our ability to measure those two things is not equal. So there is some category of people who vote who for one reason or another are not eligible to. And so in the November 2016 election in North Carolina, the State Board of Elections did an audit, a full review, and came up with some 450 voters in that category, people who either because they had a conviction and they were still on probation, or because in North Carolina your right to vote is restored once you finish probation and pay all your fines and fees. So there were some people who voted who had not completed probation, and then there were a few people who double voted, really only a couple. So this is a real small number out of millions of people who voted, but it's knowable. On the other side, people who are disenfranchised, really hard to know. If someone comes to a polling place and they're turned away because the poll worker can't find their name even though it is on the register, there's no official record of that. So in some instances, people will call the hotline. Thank goodness we have it. But we don't capture people who are discouraged. In November 2016, we did not have a voter ID requirement. Canvassers who've been canvassing since then found people who didn't go to vote because they thought there was an ID requirement and they didn't think they had the right kinds of ID. To me, that is someone being disenfranchised by all this manipulation of our election administration. But measuring that is just enormously hard. So I think we just don't have equal data on both sides. But I will say on the felon disenfranchisement piece, as advocates, what we were able to do was to explain that this was an issue about public education, and we actually, which resulted in an editorial in the Charlotte Observer saying maybe people on probation should be allowed to vote. So to whittle away the public opinion that says they shouldn't.
And I would also mention with looking at voter ID, for example, in Texas, we were able to show that there were over 600,000 registered voters who did not have the ID that the state was requiring in order for them to be able to vote. So looking at the data in the motor vehicle records and other public databases, we can also use that to show the impact of particular laws on particular voters.
Whereas, and then concomitantly, when Texas was asked what examples of voter fraud do you have, the answer was essentially zero. And I remember in the Crawford case in Indiana, it was basically conceded that there had never been a single example of in-person voter fraud in the history of Indiana, but they passed the law anyway. So I mean,
and similarly in North Carolina.
Yeah. Next question.
So we know with the new President's Voting Commission, when talking about, we know that more restrictions are probably coming because they're trying to find these 3 to 5 million people that voted
Only
illegally.
if they can pass it through Congress,
Right.
which is a
But
complicated.
my question is with looking at intentional discrimination, when we had the North Carolina case, the courts were able to find surgical precision, a lot of normal deviations. As we're going forward with the litigation and legislators get more sophisticated to kind of hide some of these factors, how are we going to proceed with the litigation, and what kind of challenges is that going to bring?
Well, so I guess I would have two pieces of advice. One is that the remedy ought to be tailored to whatever the problem is that they say exists, and that's not the case, at least with voter ID. Those 450 people who voted, ID would not have stopped them. Ending same-day registration, there was no fraud or anything that same-day registration caused. Not letting, all these measures really weren't tailored towards whatever problem they were identifying, and the Fourth Circuit noted that. I mean, that made a difference. So as this commission, starts uncovering whatever problems, then you just have to hold them to the notion that whatever they are, what are the ways to address those problems? And we also had in the legislative record, so the second point is what can you put in the legislative record? So part of it is if there are other measures that actually would address this fraud, but they're not using those, that's powerful evidence that they're actually really not trying to solve the purported problem. But then the disparate impact, right? The measures that they are considering, getting data in the legislative record about how that impacts voters of color is really important.
Anything else? No? Sir.
I'd like to ask a question that removes the focus from litigation for a minute and from race. Why do I want to do that? Because I'm from New York, and as you've pointed out, New York has probably one of the most restrictive voting regimes in the country. In the last presidential election, New York's voter turnout was 46th in the United States. People are always surprised to hear that since they think of New York as a liberal state. And efforts to broaden franchise, to have early voting, for example, or no excuse affidavit voting, or a whole range of other things that a number of states have tried, have all failed in New York, partly for partisan reasons. The Republican state Senate tends to oppose it, but even the Assembly, which passes it, they're passing it because they know it's going to be vetoed by the state Senate. None of the politicians want to change the rules. They got elected by the old rules. So the issue of voter suppression in New York is a more complicated issue. So it seems to me organizations like ACS and some of the organizations that you work for ought to be doing more to get the population more of the opinion that voting is a fundamental right, that it's American, it's not a partisan issue, and that greater voter turnout is a really essential goal. How do we do that?
Oh, I definitely agree with that approach. And as I think you noted, one way to do that is to make it easier for people to vote no matter where you are. So your question just made me think of, the reforms that are being proposed to assist and move in that direction. So I do want to mention automatic voter registration, which is a reform that's moving in the states, which puts the onus on the state to register voters. So if you have any interaction with a state agency, they determine your eligibility to vote, and you're automatically put on the rolls in some states with the option to opt out of registering. So
Did that
this has
just
been
get passed
passed
in
in
Illinois?
Oregon and in California to some extent. It just passed in Illinois recently. So that's one avenue. But also, I do believe that when you have in the public debate and in the public sphere a lot of the restrictions that are being placed on voting, it makes people think that it's this onerous process that they don't want to take the time to engage in. And so having that public campaign about the importance of voting and making it easier for eligible voters to be able to vote, I think will go a long way in encouraging I believe it was 93 million eligible voters who didn't vote in 2016. So we do certainly have a lot of work to do in encouraging full participation in our democracy. And I would say that the suppressive legislation that we're confronting doesn't help our cause at all.
I would, sorry. One thing I might add, and I think New York raises this point, is I think what the courts are looking for, and I think the broader electorate might be looking for here is some balance. So none of these things are all good or all bad. I think Justice Stevens in Crawford, no right-winger, certainly, thought that confidence in the system, even if there's no evidence of fraud, was a legitimate, non-discriminatory reason to want to have voter ID. Agree or disagree? Early voting. This is just my own personal policy view. I don't think more and more early voting is necessarily a good thing. Some early voting to eliminate as a pressure valve on election day is good. Ohio is up to something like 6 weeks. Look at the last election. Voters, I think, would feel disenfranchised if they voted 6 weeks before that election. It's not every argument, and if you take every rule that quote unquote limits access to the ballot and call it a suppression measure, I don't think we're ever going to get to a place where we can talk about these things on a policy level and reach agreement. Registration is an important aspect of it. Cleaning up the voter rolls, so long as we're not doing it in a way that discriminates against people, is necessary. I think voter ID, as long as it's not done in a discriminatory way, most people think is a reasonable requirement. But if we can't sort of talk about them in a way that just calls them all suppression or it's all integrity, we're going to be left to the courts, I think, otherwise.
The other thing I would say about voter turnout in this country is I think a significant part of the reason why America has much lower voter turnout than most countries is the nature of our electoral system, which has these winner-take-all things like state-by-state electoral college, winner-take-all. If you're a New Yorker and you care about the presidential election, the one thing you know is it doesn't matter whether you vote or not. There was never any chance of anybody winning that state except Hillary. And the same is true in Texas or Alabama or California. Whereas if you have a proportional representation system like they have in most other democracies, then your vote counts as much whether you're living among other people who agree with you or other people who disagree with you. It's a national proportional representation. And the same is often true with congressional and senatorial races where you have very little sense that there's really a contest, the way that districts are drawn, for example, nowadays. So that there may be some inherent reason why Americans are always going to vote less than most democracies just because of the way we set it up here. Professor Marshall.
We also ask people to vote in more elections here than
Well,
we
and
do.
we have it on a
than we do in
weekday,
other-
I mean, we don't have a holiday. There's a lot of things you could do to increase voter turnout. Right?
Anyway, I want you guys to put on your crystal balls and tell me what's going to happen in the court next year with some of the cases that are before it next year.
The court next year, like what?
The voting purge case?
The Ohio case?
Yeah, the Ohio case.
I mean, it's hard. I always...
What do we tell people what the case is first?
Sure. So there's a case out of Ohio under the NVRA, which statute we talked about earlier, about whether Ohio has violated it by removing certain voters from the rolls. To simplify it, you cannot, under the federal law, remove someone for not voting. But there are provisions in the statute that allow you to send notices to people who have moved. And the question is, if you send someone that notice and remove them from the rolls based on non-response to the notice plus failure to have voted in, I believe, 2 consecutive elections, which is something that's in the statute, are you violating it? And essentially, it's a really complicated statutory
It's
question.
totally statutory, right?
Yeah, and the ordinary sort of reading the tea leaves would be, well, it was granted without a real circuit split, and so you would think the petitioner has the edge going in, but I think we've learned, at least I learned in recent terms, that doesn't always work out that way. So I wouldn't know for sure how it's going to go.
How about my partisan gerrymandering case?
No chance. No chance.
No, I mean, I have no chance. So
No,
you're
no,
not
no,
gonna-
no. I guess one thing I would say about that is I had more of a question than anything. I think the consensus on the panel seemed to be that there is no risk of the intersection of race and political gerrymandering seem to be suggesting that if you get rid of both of them, you won't have a problem. I wonder, though, in the Voting Rights Act cases, if you take, for example, the obligation to create an influence district so that minorities can elect their candidate of choice, how do you disaggregate the minority's candidate of choice from partisanship? I don't know how that's done. I assume you
Yeah,
have
there's
to.
a complicated issue, which I'm not sure we can address in the next. But,
If you may get asked.
yeah, no, I'll be working on that.
Yeah.
What's your question?
For Nita, I can't tell you how excited I was to hear you mention Section 2 of the 14th Amendment.
Of the 14th Amendment, which is different from Section 2 of the Voting Rights Act.
Very
Which is different from Section 2 of the Voting Rights Act. For the past couple of years, I really have been thinking a lot about Section 2 of the 14th Amendment, and
That makes two of us.
I was wondering, because that was my question, how many of us are there out there who are thinking about this? Because it just talks about abridgment. It does not specify. And there's a remedy sitting right there. And whoever thought we would see an emoluments clause lawsuit? So I guess my question is, how many of us are there? And what do you feel like you need groundwork-wise in order to feel comfortable to bring a case?
How would this work? How the states lose some of their representation in Congress because they abridge the right to vote? Who decides that?
So this is the problem with Section 2, right? So really the question is whether or not the penalty is exclusive, right? Whether or not it can be judicially enforced. I think part of the reason it has never been enforced is because Congress, when they attempted to enforce it in 1872, they just did not know how, even though a lot of the people who enacted the 14th Amendment were still in Congress in 1872. It's a political remedy to some extent that's very difficult to implement.
Would Congress have to do it?
Yeah, I think so.
So Congress is going to say to Alabama, you get one less member of Congress because you're not letting people vote as well as they are?
Yeah, so is that going to happen?
Nah.
Right. Although I will say, let me just say, after the one person, one vote cases in the 1960s, there was a spate of scholarship where people were wondering whether or not that meant Section 2 was now justiciable. And so I don't know if there's a persuasive argument that courts should weigh in, because I do think it could create some political problems, right? If a court comes and says, look, well, maybe not, because that's what they did with one person, one vote. So I don't know. So I'm writing a book, guys. You should buy it. But I am still thinking through the justability issue. But I do think, and this is the point of my book, even if the penalty cannot be enforced, and one also has to wonder how much representation will a state actually lose? Like, how many people will they have to abridge, whose right to vote will they have to abridge in order to lose representation? Texas will probably be affected, but smaller states, you do have to wonder whether or not it'll be an effective political penalty.
Just because the percentage of their
Right, just
congressional
because of
delegation would be
percentage.
so high. Yeah.
Exactly. But I do think Section 2 is part of the 14th Amendment, and it does affect our understanding of Section 5, right? So, and it affects our understanding of Section 1. So when we think about abridgment and when we think about the right to vote, Section 2 is the only provision of the 14th Amendment that mentions the right to vote. I'll stop.
Okay. Yes, sir.
Quick question about the census. Are the recent developments, the resignation of the head of the Census Bureau, that seems like a budget crisis there, is there concern that the 2020 census, either intentionally or inadvertently, will sort of skew the underlying demographic numbers that form the basis for all of the rest of the concerns we're talking about here today?
Yes, there's a concern. In fact, the GAO has rated the census as high risk at the moment, and there's also the fact that the census is moving more to an online data collection. And then when you think about populations, the ones that we serve that are perennial undercounts in the census, there is a lot of work that needs to be done there. And so, there's advocacy to get the census the funding it needs. They've also cut, I think, half of their regional offices. So, advocates are working with the census to encourage and move them on, making sure there's as robust process as there can be. But the money needs to be there, and that's where the advocacy is right now.
Right. And they're certainly concerned that they may add questions that could be actually deterrents to participation. If you ask people about their citizenship status, for example, that's going to be a big problem. One final quick question.
Yeah, a quick question for those of us concerned with maybe curbing some of the partisan gerrymandering in the Whitford versus Guild case. How concerned should we be about Justice Kennedy joining Justice Alito's dissent in Cooper?
Well, what I said in the press about that was that you shouldn't attribute a great deal of significance to the exact wording of somebody else's dissent when you join it. He agreed presumably with the outcome of disagreed with the majority's outcome, but I don't think that justices spend a lot of time editing each other's dissents when they join them, and that it's pretty clear to me, based on history and things he said in the past, that Justice Kennedy is very concerned about partisan gerrymandering, and is just looking for a reassurance that we have a standard and a method that can actually identify the ones that ought to be unconstitutional. So I didn't get too upset about it, although there was certainly a lot of press about it, because there was some bad language that Justice Alito put in that opinion. But I think we have to stop now, and I want you to ask you to thank our panelists.